In his treatise on politics, Aristotle raises the question, what is law? And as is his manner, proceeds to rehearse what others have said. Some, he tells us, regard it as a gift from the gods. But his own definition is characteristically economical, even academic. Law, he says, is reason without passion. Dio pera nuerexios nous onamos estin. Reason without passion. Philosophy of law, or jurisprudence, has long been of interest to philosophers. Cicero composed a treatise on the subject, and in Book 2 of the work, he offered this definition, quote, "The law was neither a thing to be contrived by the genius of man, nor established by any decree of the people, but a certain eternal principle which governs the entire universe, wisely commanding what is right and prohibiting what is wrong. Therefore, they called the original and supreme law the mind of God." Well, in the dialogue that Cicero stages between Marcus and Quintus, it is Marcus who develops the thesis that as the divine mind rationally passes on what is virtuous and what is vicious, so too does law stand as right reason. Now contrast this with the remark made by the American legal realist Jerome Frank, to the effect that the outcome of adjudication may well depend upon what a judge has had for breakfast. So, between the mind of God and the dietary preferences of judges will be arrayed a number of theories on the nature of law, and therefore on what our dispositions and expectations should be regarding the law itself. Something emanating from the mind of God, or something determined chiefly by ham and eggs. Now, just to keep an already complex historical record and conceptual terrain manageable, I would just stipulate that philosophy of law begins when we can identify a position taken on the origin and source of law and its resulting authority. On this understanding, the oldest tradition within philosophy of law is theological. Human laws, or at least the principles by which punishment is exacted and disputes settled, are found either in prophetic revelations, or in the authority of temple priests, or in the presumably inspired wisdom of the sage or tribal chief. So Cicero's reference to the mind of God hearkens to this most distant origin of legal concepts. As for times or settings in which this minimal theoretical framework is missing, well, they are best understood as pre-legal. In this sense, I would classify as pre-legal the merely customary habits of social groups, no matter how large the group, no matter how venerable the custom, if the customs themselves have not been subjected to critical appraisal. Again, we see that the defining mark of philosophy is a mode of criticism designed to test the validity or truth of propositions. Now, from the time of ancient reflections on the nature of law until the first half of the 19th century, the dominant perspective in philosophy of law was that of natural law theory. Though expressed in various ways, the perspective itself invariably included and includes assumptions about human nature and about the nature of that social and physical reality in which human nature itself must find a place of security and nurturance. We've heard Cicero on the subject. Consider now the standard legal textbook of the early medieval period, the Institutes of the Emperor Justinian, promulgated in AD 533. The work begins with a definition of justice as, quote, "the constant and perpetual wish to render every one his due," close quote, proceeding then to divide law into the classification that Cicero himself had developed: the natural, the common, and the civic. Now, of natural law and the difference between it and civic law, Justinian's Institutes declares that, quote, "the law of nature is that law which nature teaches to all animals, for this law does not belong exclusively to the human race, but belongs to all animals, whether of the earth, the air, or the water. The law which a people makes for its own government belongs exclusively to that state and is called the civil law. But the law which natural reason appoints for all mankind obtains equally among all nations," close quote. So here in the 6th century AD, the authoritative treatise on law speaks of universally binding precepts recognized by natural reason. 7 centuries later, and in this same tradition, Thomas Aquinas will define law as, quote, an ordinance of reason, promulgated by one who is responsible for the good of the community. An ordinance of reason. Now, moving ahead to the 17th century, we find John Locke in his 2 treatises of civil government, leaving no doubt as to the ultimate source of law. Asking how human affairs would be managed in that state of nature that would exist before the advent of all civil society, Locke argues that we would not have an anarchy. Rather, by our very nature, there would be attempts to establish order and justice. John Locke puts it this way, quote, and that all men may be restrained from invading others' rights and from doing hurt to one another, and the law of nature be observed, which willeth the peace and preservation of all mankind. The execution of the law of nature is in that state put into every man's hands. For the law of nature would, as all other laws that concern men in this world, be in vain if there were nobody that in that state of nature had a power to execute that law, close quote. So we see then that from the 4th century BC to late in the 17th century, that is to say, for more than 2 millennia, a common thread of jurisprudential reasoning runs through philosophical attempts to comprehend the sources and the nature of law. Knowledge of other peoples with radically different forms of social life did not disturb this conception of law. Aristotle was well aware of cultural diversity, and it led him to conclude that it was entirely fitting, quote, that Hellenes shall rule barbarians, close quote. Now, this was not a defense of imperialism, but of the sound proposition that a people is best ruled by the rule of law itself, far better ruled than by tyrannizing warlords. So too with Captain Cook's voyages and other sources of information about so-called primitive peoples. The standard and often smug view was not that they were a challenge to natural law theory, but that they were, quote, savages awaiting the civilizing nurturance of a more developed people. The Enlightenment, however, insistently drew attention to the confusion between what many took to be the natural state of affairs and states of affairs that had simply gone on too long, with formidable powers seeking to preserve the status quo. Revolutionary upheavals begin with dissatisfaction, but they gain momentum through the force of ideas. And early in the 19th century, England was the setting for major reforms, with specific parliamentary acts passed in the 1830s. One of the chief aims of the reformers was to break down barriers that had long denied whole segments of society access to the political process. It was also understood that these very segments of society had been denied access to the very education that might prepare people for responsible citizenship and alert them to the historical and social conditions responsible for prevailing conditions. One of the leaders of the reform movement was Jeremy Bentham, a friend to James Mill, a profound influence on John Stuart Mill's early education. Born in 1748, a lawyer's son, Bentham was precocious, intellectually inquisitive, learning Latin at the age of 4, and finding the Oxford curriculum too easy by half. He turned away from the study of law, in part as a result of all things of William Blackstone's lectures on the subject. Now studying firsthand the sheer complexity of law, this restless Bentham dubbed it demon and chicane, and set off instead to change the world. In a subsequent lifetime of reformist activity, he could claim as one of his greatest achievements the successful lobbying for a college that would eliminate the traditional obstacles faced by working classes as well as by Catholics, Jews, and dissenting Christians. Through the resulting University College London, which opened its doors in 1828, it wasn't founded by Bentham, but it realized fully his plans for a reformed academic climate. Bentham's preserved body still sits near the entrance to the dining room at University College. I've seen it in recent years. He seems to be doing fine. Bentham died in 1832, but he lived long enough to have a hand in the appointment in 1829 of one of his own students, John Austin, to the chair of jurisprudence at this new University College. Now, Austin, by that date, had already terminated his own law practice. He had an extremely influential circle of friends, however, including Bentham, James and John Stuart Mill, Thomas Carlyle. It is remarkable that in the few years he occupied the chair of jurisprudence, he would prepare but a single volume for publication, and that volume, in time, would profoundly affect how law itself would come to be understood. The book was essentially his lectures and was published under the title, The Province of Jurisprudence Determined. Even this work might have been left on the shelf of forgotten tomes had it not been for his faithful and resourceful wife, Sarah, who saw to it that a revised edition of the work was published as late as 1873. It would be too much to say that Austin or Austin's book or any single book established the field of analytical jurisprudence. Nonetheless, one searches without success for works before Austin's that so clearly distinguish moral and legal concepts and reserve independent status to each. He states the argument this way in his fifth lecture, quote, "The existence of law is one thing, its merit or demerit is another. Whether it be or be not is one of inquiry. Whether it be or be not conformable to an assumed standard is a different inquiry. A law which actually exists is a law, though we happen to dislike it, or though it vary from the text by which we regulate our approbation and disapprobation." A law is a law. In German, Gesetz ist Gesetz, an established principle in German law at the time Austin studied at Bonn. At the root, law is a command, perhaps in the form of a wish, covering a range of actions, and declared by the sovereign. The sovereign may be one person, might be a parliamentary or congressional body, a group of chieftains. What establishes sovereignty is the habitual obedience secured through the power of punishment or the means by which to visit an evil on those who disobey. Note what law is in its essential purity and what it's not. It's not a moral maxim, not a religious belief, not the voice of conscience, not an ordinance of reason, not the mind of God. That a given law may agree with what one takes to be the will of God is, of course, possible. It might even be desirable. That the law does not require what conscience forbids is a distinct benefit to one whose conscience is thus supported. But what makes the law law is neither its agreement with religion and morals, nor its compatibility with individual consciences. What makes law is that it is expressed by those possessing sovereign power. So here then is a succinct and early statement of what came to be called legal positivism. Law is what is enacted or authoritatively promulgated and enforced. The study of law is the study of actual enactments or commands. It is a branch of neither moral nor political philosophy, but a subject unto itself, calling for rigorous analysis of such key notions as law, duty, obligation, rights. The focus is on the legal concepts themselves, not on their allegedly moral dependencies or sources. Austin was fully prepared to accept both moral laws and divine laws, understanding each of these to be different from each other, and both of them to be fundamentally different from the positive laws brought into being and enforced by sovereign power. Analytical jurisprudence is the subject of the last of these. Moralists and theologians can claim the rest of the terrain on Austin's account. Now, this is all neat and quite stimulating, but it does tend to leave some fundamental issues in philosophy of law more or less untouched. On neither Austin's account, nor those advanced by his successors in legal positivism, is it clear just what enters into the concept of sovereign. Austin's most famous successor was Oxford's H.L.A. Hart, whose The Concept of Law appeared in 1961. Now, one objective of that work was to repair certain features of legal positivism that had over the years attracted serious criticism. Austin's concept of sovereign was notoriously fluid, leaving the issue of valid authority virtually intractable. And his command theory of law, which ties the command function to little more than the power of enforcement, seemed to confer the standing of legislator on unwanted types. After all, the gun-toting thief who commands us to hand over our wallet would seem to qualify as a lawgiver. Now, Hart's attempt to eliminate such counterintuitive possibilities took the form of something he called the rule of recognition. You see, what the thief or the highwayman lacks, but Congress possesses, is the recognized status as a source of positive law. Thus says Hart, quote, "To say that a given rule is valid is to recognize it as passing all the tests provided by the rule of recognition," close quote. Well, understood this way, law is a collection of laws, and each of these stands as a social fact. It's a social artifact, one might say, not unlike other useful items that societies create for their own purposes. We make clay pots, we make teaspoons, we make tractors, we make laws. Now, as we recognize the Motor Vehicle Bureau as the place that prints valid driver's licenses, so we recognize Congress as the body that passes valid laws. So if let's say the local pizza parlor were to advertise, quote, "valid driver's licenses given with every order," close quote, we would be suspicious enough perhaps to call the police. Not because the offer is immoral, or even because the pizza shop would require high standards of visual and motor skill. Rather, it's simply the wrong place to be granting licenses to drive. So the rule of recognition corrects one of the basic flaws in command theory. It enables all of us to determine whether or not a law is valid by determining whether it satisfies the rule of recognition. Well, of course, the Nazi Party in Germany was a duly elected party by an overwhelming majority. It appointed judges in the traditional manner that judges got appointed, and it otherwise satisfied whatever goes into the rule of recognition in the matter of how law comes about. Do we want to say that this was sufficient to establish that what was ever thereby enacted would stand as valid law? Now, the natural law critique of this entire line of reasoning has been provided by a number of writers, rather early on, contemporary with H.L.A. Hart, by Lon Fuller, in what remains a classic treatise titled Positivism and Fidelity to Law, a reply to Professor Hart. Attempts to distinguish between law and morality, as if the former could have any sort of real function in the absence of moral precepts, fail at both the practical and conceptual levels of analysis, according to Fuller. The moral and rational powers actually presupposed by the rule of law are also at work in distinguishing between law as something to be faithfully obeyed and law as but a word seeking to conceal arbitrary, immoral, tyrannical modes of control. Fuller is fully prepared to insulate the rule of law from specific substantive moral mandates, but he insists nonetheless that the very concept of law requires a procedural morality that will ensure the law's fairness, ensure its consistency in application, its clarity. In his 1964 book, The Morality of Law, he puts the matter this way, quote, "What I have called the internal morality of law is a procedural version of natural law, concerned not with the substantive aims of legal rules, but with the ways in which a system of rules for governing human conduct must be constructed and administered if it is to be efficacious and at the same time remain what it purports to be," close quote. Natural law theory and legal positivism, however, do not exhaust the options in philosophy of law. An influential writer in this field in recent years has been Ronald Dworkin. His criticism of legal positivism begins with the observation that courts must often decide cases for which there are no precedents, and nothing in the record of social facts, so-called, that would be sufficient to settle the matter. One instance cited by Dworkin is Riggs versus Palmer, which had to decide whether a murderer nonetheless was still to enjoy what his victim had bequeathed to him in a will. Now, the maxim according to which, quote, no one is to benefit from the commission of a crime, close quote, was not in the settled law of the jurisdiction, and in any case, it's a patently moral precept in character. But it was just this reasoning that led to the decision in Riggs. To summarize the conclusions reached by Dworkin in his analysis of law, the authority and validity of law result from its embodiment of moral aims that are widely shared within the community and of a nature to justify the values and practices of that community. In Riggs, the court achieved the best outcome, defined as the one that matched most closely the moral principles operative within that community at large and at that time. On this understanding, says Dworkin, quote, judges should decide hard cases by interpreting the political structure of their community, trying to find the best justification they can find in principles of political morality for the structure as a whole, close quote. Now, some are going to see in this little more than advocacy, indeed, advocacy of judicial activism, even an apologia for the status quo. I want to pause here to say that Professor Dworkin has never concealed his support of legal activism. But I should think that in the Lincoln-Douglas debates, for example, Douglas would have made very good use of Professor Dworkin's understanding of the nature of law. Much of the South, understood surely as a community, accepted slavery as a property right, and more important, the right to make that judgment as a state's right. So that was endemic to the culture, widely shared values. To some extent, Dworkin's theory is a descendant, if not an acknowledged one, of that legal realism that flourished in American jurisprudence under such defenders as Oliver Wendell Holmes, Roscoe Pound, Jerome Frank. Holmes famously reduced the concept of law to that which would allow him to predict what judges and juries will decide in a given case. The best understanding of law on this account is an instrumental one. Law is just a tool designed to achieve certain desired outcomes. It functions in such a way as to make easier or more efficient the attainment of social goals. Its authority is not found in moral precepts, even in tradition or custom. Its authority just is the act of deciding cases. Jerome Frank was himself a federal judge. In one of his lectures on legal realism, he discusses a Supreme Court case settled by a 6-3 decision, and he asks, from the petitioner's point of view, just what was the law. As Frank observes, until the court ruled, there was no answer whatever to the question. Quote, this is Frank, law then, as to any given situation, is either A, actual law, i.e. a specific past decision as to that situation, or B, probable law, that is, a guess as to a specific future decision. Now, Kant, as might have been guessed, composed a most analytical exposition on the nature of law, understood as part of the metaphysics of morals itself. The heading under which we find his philosophy of law is, quote, the science of right, which, he says, has for its object, quote, the principles of all the laws which it is possible to promulgate by external legislation. It is from this science that the immutable principles of all positive legislation must be derived by practical jurists and lawgivers. And what is that principle? Well, as Kant puts it, every action is right, which in itself, or in the maxim on which it proceeds, is such that it can coexist along with freedom of the will of each and all in action according to a universal law. Well, law then is derived from a principle, and the principle is one that seeks to preserve and honor the moral liberty of rational beings, consistent with the freedom of all such beings. That freedom, too, comes under the direction of a universal law, which, as we have seen in the lecture on Kant, is a moral law. With Kant, we are returned again to the law's moral purposes, derived from the idea of freedom and the dignity of beings who are rational as such. Of rights, Kant asserts that only one is a natural and inborn right. All others are derived from positive law and tradition. So what is the core right, the inborn one? Quote, freedom is independence of the compulsory will of another, and insofar as it can coexist with the freedom of all, according to a universal law, it is the one sole original inborn right belonging to every man in virtue of his humanity. There is indeed an innate equality belonging to every man, which consists in his right to be independent of being bound by others to anything more than that which he may also reciprocally bind them. These lines provide a foundation for one of the most influential works in contemporary philosophy of law, John Rawls's A Theory of Justice. As with Kant, Rawls's goal is the preservation of freedom from the compulsory will of another. The reciprocation discussed by Kant appears in Rawls as a fairness criterion, justice as fairness, grounded in that principle of equal liberty that gives no one more extensive freedom than that possessed by others. And Kant's categorical imperative, in a somewhat quirky way, supports, or at least is intended to support, what Rawls calls the difference principle. Social and economic inequalities should be arranged so that they are to the greatest benefit of the least advantaged before they improve the condition of the more advantaged. Well, I should say, for all its celebrity, Rawls's A Theory of Justice, I must say, is disappointing and incomplete. It's surely not a Kantian maxim that the claim one has on the general resources is proportioned to the degree of disadvantage. There are just deserts in Kant, after all, such that one might well have earned one's disadvantages. And what can be said of equal liberty if its exercise leads to the very differences in social and economic conditions that are then to be cancelled or reduced via the difference principle? All due respect to Rawls and his work, but you see, more questions raised than answered. There is a small step, actually, from the position according to which law is no more than a social instrument to the very use of law to secure social conditions dictated by theories which, rather than outcomes of rigorous criticism, are presented as if they were protected from criticism. In the end, just in case we are vigilant and lucky, law is an ordinance of reason, and it is promulgated by one who is responsible for the common good. Now, what question does this leave wide open? The question it leaves wide open is just what is the common good? It's not within the province of philosophy of law to determine what, given the nature of human nature, would be the common good of all. And in order to address that question, one is inescapably led back to fundamentally moral considerations, such that even if one were to accept a positivistic distinction between morals and jurisprudence, moral philosophy and philosophy of law, and were simply to accept that the function of law is to secure ends compatible with the good of the community, with the values of the community, etc., we would still be driven back to a critical assessment, a critical identification of just what constitutes a benefit to all, what constitutes the good of the community, what would be the means by which to measure and assess the extent to which the freedom of one has been honored in a proportional way to the freedom of all. Philosophy of law, like philosophy itself, is extremely useful at the level of criticism, makes no promises really, and shouldn't make promises at the level of great and abiding and true discoveries. Philosophy of law is alive and well, and by the way, in case listeners are interested, Natural law theory, around for so long and then replaced, seems to be sneaking back in, very often under disguise, sometimes in the darkness of night. Stay tuned.